Hey, it's Guy DiMartino. I'm a Northwest Indiana estate planning lawyer. Today I'd like to talk a little bit about retirement accounts and how they can play into your estate plan. And it's a complicated type of situation, and you really need to discuss this with your estate planning lawyer and your financial advisor. Changing the title of your retirement accounts sometimes can go ahead and have tax consequences to a trust or something along those lines. But typically, if you are married or if you have kids that are adults, you might just want to have your spouse as the beneficiary of the retirement accounts, and that means that should you pass away, the funds in the retirement account will go ahead and pass to your spouse outside of any will or outside of any trust that you have. So that would be a straight primary beneficiary. You can also have contingent or alternate beneficiaries. And that would mean that if your spouse predeceased you, the funds would go to the secondary, alternate, or contingent beneficiary. So, and when you're looking at that, you have to look and see regarding age. For instance, if your kids are very young, you're going to have to do something to protect those assets, or if they're young adults, you might not want them to go ahead and get a ton of money. So you'll have to structure what would happen under those circumstances. I recently handled an estate for a guy who was a single guy and had no heirs that were close to him or family members. No kids, no surviving spouse. So what happened was this estate plan, the beneficiary was the estate. The will had a pour-over provision, so the monies went into the estate and then went into the trust. But because it was a substantial amount of money, there was tax consequences that happened where the trust had to pay a decent amount of money for the taxes because of the retirement funds. Whether he could have structured it a different way is really for a financial advisor and a CPA or somebody who deals with those issues could have possibly structured it. But this gentleman did not have any immediate family, so this was probably the best way under his circumstances. If he would have lived longer, he would have been able to dissipate those assets by taking his minimum distribution out of his IRAs and stuff like that. And if he would have lived longer, the funds would have been there to help him in his retirement, but he did not. This is just something that you need to think about. What are you going to do with your 401k? What are you going to do with your IRA? And you have to look at these things in scope of your entire estate plan. Also in Northwest Indiana, we still have some companies that have pensions. I know in a lot of part of the United States, there's a lot of places that don't have pension plans anymore, but we still have a lot of pensioners in the mills and stuff. So you have to go ahead and look at the terms of the pension. Some folks, the pension will stop after they pass away. Others, it will transfer to their surviving spouse and continue paying the pension benefit to their surviving spouse until the surviving spouse passes away. So you have to look at the pension documents and the plan documents to determine what to do regarding that. If you have any questions about how your retirement funds will play into your estate plan, you want to bring it up with your estate planning lawyer you want to bring it up with your financial advisor, and you want to bring it up with your accountant. Until the next time, I am Guy DiMartino. Have yourself a great day.